Well, good afternoon, everyone. I'm Merit Jane O'Dean of SEPA, and it's really a great pleasure for me to welcome all of you to SEPA this afternoon for joining this discussion on antitrust, big tech, and free speech. It's really a conversation with Bilal Sayyed, who is the director of the Office of Policy Planning at the Federal Trade Commission. And SEPA is very pleased to be collaborating with the Knight First Amendment Institute at Columbia University, and really thank them for their collaboration. I think today's topic is one of enormous interest to our faculty and our students, and I'm very pleased to see such a great crowd, including, I think, from people across campus, not just from SEPA. It's a subject of great interest to me as a former antitrust lawyer and official at a certain point in my life. But, we weren't really focusing on these questions when I was in the antitrust division. But they are absolutely front and center discussions, I think, in public discussion in the United States and around the world. I would say it's animated a lot of public debate, to my mind still inconclusive public debate about how best to regulate the big tech platform companies, with what tools and for what ends. Congress has held hearings, the FTC as well. There seem to be specialized working task forces in the antitrust agencies, maybe some investigations underway, actions by states, congressional committees at work, ideas coming forth by the co-founder of Facebook and other tech leaders on what needs to be done, around challenges related to proliferation of disinformation on social media platforms. What are the competitive harms associated with online platforms and market power? And what's the role of data and privacy in competition? Competition in the tech sector is often structured around data, and there's really some interesting new work, I think, being done in the academy and elsewhere on what is the value of data, how it influences our thinking about market definition, barriers to entry, and anti-competitive problems. Now, I just note that U.S. antitrust law has not traditionally been adverse to bigness, but has looked at the consequences of it, including with respect to innovation markets and foreclosure effects on small and medium-sized firms. In other words, potential competition. But I might also note that these latter areas have not been at the front and center of U.S. antitrust policy until, again, perhaps somewhat recently. And these are hard areas to establish empirically. And antitrust law in the United States works from evidence, rigorous data about conduct and its consequences. So it seems to be a moment when there's considerable interest in agencies and Congress in thinking again about antitrust laws, both with respect to deconcentration goals, you could say that's a traditional focus, but as well as broader societal and political objectives beyond sort of consumer welfare narrowly defined. So today, with collaboration with the Knight Institute, I think we're also engaging in a broader discussion about how antitrust is relevant for speech itself. Maybe we'll have a discussion about what are the corrective measures to the challenges, whether through antitrust or other instruments. And that certainly came up in a fantastic conference that they organized this fall. I always think about what is the ability of the antitrust agencies to work with other sectoral regulators. It's a complex challenge for antitrust enforcement because there are other tools and they interact with antitrust in different and complex ways. And one of the big debates, of course, that we're seeing is a discussion around the Communications Act of 1996, which provides internet companies with immunity for content posted by users and whether that should be re-examined. And of course, to make matters even more complicated, we live in a global world with very heterogeneous approaches to these questions between countries. even countries that have mature systems like the US and Europe. So these are highly consequential, important topics where, speaking for myself, I would say I'm quite unsatisfied with the idea of either doing nothing or assuming we should break up these companies. And so instead, it's left to the agencies to do some really hard thinking about the evolution of our digital economy and what it means in a global context. And I think we are really fortunate to have with us someone to speak to some of these issues. I don't know exactly what he will speak to, and so I may have said more about subjects he doesn't wish to address than what he intends to speak to. But let me say, Bilal joined the FTC as director of the Office of Policy Planning, which is a really important office in the FTC. It's a brain trust around deep analytical thinking around the direction of antitrust policy. And this is his third period of service at the FTC. He also spent years in private practice at one of the great, couple of the great law firms in this field. And he has also held academic appointments at the George Mason Anton Scalia Law School, where he taught antitrust and competition law. And moderating and leading today's discussion will be Katy Glenn Bass, who is the inaugural research director at the Columbia University's Knight First Amendment Institute, which is a fantastic place, and I hope she'll tell us a little bit more about it, where she has been responsible for both conceptualizing and developing the Institute's research initiatives. So thank you both for being with us, and if I may ask Katy to take us forward.
Thank you very much, Dean Jano, and thank you to SEPA for hosting this event for us. And thanks to all of you for coming. It's really great to see such a good crowd here. I just wanted to offer some very brief context for today's event. The Knight Institute is based here at Columbia. We defend the freedoms of speech and the press in the digital age through strategic litigation, research, and public education. Today's event is part of a longer-term project we're engaged in, looking at the tech giants, monopoly power, and public discourse. In November of last year, as the Dean mentioned, we organized a symposium looking at the power of the largest tech companies to shape online public discourse and whether anti-monopoly tools might be useful to counter this power. Experts in law, technology, economics, policy, and communications wrote 12 papers for the symposium. The final versions of those papers are being published right now on our website, knightcolumbia.org. And if you're interested, you can also grab a symposium program out where you registered to come into the room. We're very grateful to Bilal for accepting our invitation to come to Columbia. He and his colleagues at the FTC are deeply engaged with the same questions that the Institute Symposium explored. And with that, I'll invite him to come up and talk to us. Thank you.
Okay, well, thank you, Dean, and thank you, Katy, for inviting me. I watched the symposium. Two of my colleagues from the office came down for it, and I enjoyed it. As my remarks will note, it was quite beyond the scope of most of what I do, but that's okay. I found it very interesting. And I get to meet new people because so many people are now interested in antitrust, and it makes me seem much more interesting. So anyway, so before beginning, I have to note that my remarks do not, at least necessarily, reflect the policy or views of the Commission or of any individual commissioner. Although I'm hopefully not off on any kind of tangent, and these things will be helpful. So the Knight First Amendment Institute Symposium, a few months ago, is I think further evidence of the broad interest in the question of whether more antitrust enforcement or the more expansive use of antitrust law is at least part of the response to concerns associated with the allegedly negative effects that the large digital companies or platform companies have on commerce, politics, wealth, and income distribution, and perhaps even the mental and physical health of their users and customers. Now, as I was sort of alluding to before, I consider myself a fairly mainstream antitrust lawyer, excuse me, and not too familiar with other areas of law. So as I said, many but not all of the concepts and ideas advanced at the symposium were somewhat foreign to me or novel to me. With the exception of the Norr-Pennington doctrine, it's been a long time, I think, since public discourse or more concerns, or more broadly First Amendment concerns, excuse me, directly influenced antitrust law. So, I hope my comments this afternoon will have some resonance with non-antitrust lawyers and practitioners, but I do worry that some areas we're sort of talking past each other. And that's, in fact, why, these symposium efforts are very important. Now, I'm not going to spend, notwithstanding my sort of limited framing, I'm not going to spend, the next 20 or so minutes throwing cold water on the ideas expressed at the symposium. I learned from one of my bosses at the FTC, Chairman Tim Uris, that it's important to have a positive agenda if you're lucky and fortunate to have a managerial role at a federal agency. In fact, I think that's sort of the most important thing. So after a little bit of history on an earlier revolution in antitrust enforcement, one that I think is very similar to what is being proposed today, I'll provide a short summary of some of the things we're doing in the Office of Policy Planning and discuss how it relates to what's happening internationally, and hopefully leave a lot of time for Q&A. So like a revolution in the FTC's enforcement and use of its Antitrust and Consumer Protection Authority occurred 50 years ago. The foundation of that revolution was a recommendation that the antitrust laws be used and strengthened to effect a significant restructuring of the American economy. The Neal Report, which was a report coming out of President Lyndon Johnson's task force on antitrust policy, found that highly concentrated industries represent a significant segment of the American economy, and that in support of effective antitrust, the report recommended legislation to give antitrust enforcement authorities a clear mandate to use established techniques of divestiture to reduce concentration in industries where monopoly power is shared by a few very large firms. The report also recommended legislation that would prohibit mergers in which a very large firm acquires one of the leading firms in another concentrated industry. Now, the task force recognized that the primary impact of that legislation would be on diversification or conglomerate mergers, and explained that the basis for this recommendation was an understanding that Section 7 of the Clayton Act was not effective against mergers where the detection of adverse effects would depend on factual and theoretical judgments that are highly speculative. Now, perhaps that's a good thing, that we don't block mergers that are on the basis of speculative conclusions. But it is, in fact, what I think people are asking us to do with respect to acquisitions of small, allegedly potential competitors, something the dean had mentioned. Now, the spark of the revolution in the FTC's enforcement and policy agenda back then was two reports that concluded that the FTC was failing in its mission to protect consumers and maintain competitive markets. The Nader report on the Federal Trade Commission, which was the summer project of a handful of law students, criticized the Commission's consumer protection program. And although some practitioners and agency officials found the report's findings unfair, they also recognized the criticisms as nothing new. Now, I think they might have meant that comment to be dismissive of the students and their work, but it sounds pretty damning. And then the Kirkpatrick report, more formally a 1969 report of the American Bar Association Commission to study the Federal Trade Commission, heavily criticized the FTC's application of its Antitrust and Consumer Protection Authority. Excuse me. It found that the agency largely pursued trivial matters, and absent a radical change and significant redirection, believed congressional action to shutter and replace the agency would be appropriate. We see some of this same type of criticism today directed at both agencies' alleged failure to block mergers or attack conduct of the digital platform firms. So now, in response to this criticism in the late 60s, the FTC began a decade-long effort to deconcentrate significant sectors of the U.S. economy and to expand significantly of its industry-wide consumer protection trade rules. In addition to large monopolization and attempted monopolization cases against approximately 24 entities, corporate entities, the agency also initiated a significant rulemaking effort and completed 6 major consumer protection trade regulation rules and had an additional 16 rules pending during the early and mid-'70s. The appointment of Michael Perchuk, the Chief Counsel and Staff Director to the Senate Committee on Commerce, Science, and Transportation from 1965 to 1976, his appointment as chairman in 1977 added a boost to the FTC's expansive use of its Antitrust and Consumer Protection Authority. Now, Chairman Perchuk wanted to use the Commission's authority to restructure the economy, and this now is a quote, into line with the nation's democratic, political, and social ideals on issues such as social and environmental harms, including resource depletion, energy waste, environmental contamination, worker alienation, and the psychological and social consequences of marketing stimulated demands. This sounds very much like what many advocates are proposing we do now. Chairman Perchuk also called for the agency to turn to new sources of professional expertise, such as experts in tax policy and planning, business planning, marketing science, sociology, psychology, history, and political science to help formulate competition policy. Now, you could write books on what the agency accomplished or failed to accomplish during that 10-year period. But, I and many others have reviewed the history of their FTC's antitrust investigations of the 1970s, and what stands out to me and many others is not only the breadth of the FTC actions, but the nearly unanimous agreement that the agency embarked upon its efforts to reshape whole industries and a substantial portion of the U.S. economy without a clear framework to guide what it was looking for and how it would analyze what it found. Bob Potofsky, who was a graduate of this law school and also FTC chairman during the Clinton administration, and no piker in enforcing the antitrust laws, concluded that the industry-wide investigations and cases that were initiated under Section 2 with no clear theory of what constituted monopolizing behavior. Jim Liebler, a former head of the predecessor of my office in the 1970s, wrote similarly, most industry-wide matters have been instituted without any clear articulation of a theory of how successful prosecution of the case will improve economic welfare. These conclusions are common to the literature evaluating the FTC's antitrust and consumer protection program in the 1970s. I won't even talk about the DOJ investigation into whether automobile manufacturers were illegally tying car radios, stereo systems, into automobiles. But you can see how bizarre, well, maybe some of these things were. Now, at the beginning of the Reagan administration, this revolution had run its course, with the agency having very little to show for its efforts to restructure the U.S. economy and better oversee consumers and firms' market interactions. 3 appellate cases in the early to mid-1980s further circumscribed some of the agency's aggressive efforts to apply its unfair methods of competition authority broadly. Now, this is well before the so-called conservative takeover of the judiciary. Now, starting with the Reagan administration, the FTC, across politically different administrations, has pursued sharply more defined and restrained antitrust and consumer protection missions. That change in antitrust reflected new learning that had begun to influence Supreme Court antitrust doctrine, and it was primarily driven by the scholarship of academics. The most prominent were Phil Arita, Don Turner of Harvard, Frank Easterbrook, Richard Posner, and Robert Bork, with the University of Chicago. Now, these scholars applied microeconomic principles to antitrust questions and paid attention to empirical work, which led them to conclude that a lot of the pre-1970s antitrust case law was inconsistent with rational, pro-competitive, and economically beneficial behavior. Now, over time, the use of microeconomic principles formed the underpinnings of mainstream antitrust analysis in the academy, the courts, and the antitrust agencies. Justice Stephen Breyer was also instrumental in applying microeconomic principles to antitrust and regulatory analysis, both in his work as a Senate staffer for Ted Kennedy and also as an appellate court judge. Now, that broad antitrust consensus that has existed in relatively stable form for 25 to 30 years is now, of course, being challenged. There's a strong body of opinion that challenges the enforcement choices and performance of the Commission and the Department of Justice in the last 30 to 40 years, Republican and Democratic administrations both. Now, these challenges are of two kinds, part as the Dean alluded to. First, some recent economic literature concludes that the U.S. economy has grown more concentrated and less competitive over the last 20 to 30 years. This happens to correlate with the timing of the change to a more economically based antitrust policy, beginning in the early 1980s. Thus, some believe that the antitrust laws as developed in the courts, allegedly the so-called Chicago School antitrust framework, that neither the courts nor the antitrust agencies have been effective in doing what antitrust is supposed to do, maintain competitive markets. Second, some question the focus of antitrust. The focus on consumer welfare as the goal of antitrust and the protection of the competitive process as opposed to protecting competitors, and call for antitrust enforcers to take account of policy goals beyond consumer welfare. Inequality, labor issues, and excessive political power are perhaps the main examples. I cut a few things. So I want to leave time for questions. These questions, from the right and the left, pose a challenge for antitrust agency leadership, the courts, and legislatures. We should think hard about whether significant adjustments to antitrust doctrine, enforcement decisions, and the law would be beneficial if antitrust could or did accommodate these other concerns. It would be a mistake to adopt a policy of continuity without some serious reflection and evaluation of these claims and studies and the like. And so while I think there's a lot to learn from the experience of the 70s, which is, don't exceed your mandate, the progress, this is a quote from another graduate and former chairman of the FTC, another graduate of the law school, Bill Kovacic, the progress of the Federal Trade Commission has built heavily upon the willingness of its people to assess their work critically and explore possibilities for improvement. So, a quarter century ago, Bob Patofsky reinvigorated the agency's research and policy function with the 1995 Global Competition and Innovation hearings. 25, 30 years ago, the big concern was how do we deal with global markets in antitrust? And what followed this work by Chairman Patofsky was some of the work the Dean participated in with a review of sort of international antitrust issues. Now, Patofsky's hearings were the first major step in reestablishing the FTC as a key modern center for competition policy research and development. So we followed that model earlier in the current chairman's term in initiating a hard look at current antitrust doctrine. We announced a series of competition and consumer protections to help us think through whether changes to the Commission's mission, enforcement efforts, and policy priorities was warranted. It was a significant undertaking, and we heard a lot, including especially about the digital platform companies and the antitrust challenges they present. So that's where I'm going to focus the rest of my remarks, at least on how we're responding to that. Right? Now, some participants and commentators called for a program of antitrust enforcement that would more aggressively investigate, challenge, and remediate or reverse the conduct and transactions of significant technology and digital firms by, for example, substantially increasing legal challenges to vertical integration by acquisition basically more challenges to vertical mergers, preventing certain firms from being both vertically integrated and a supplier of services to competitors, basically questioning whether we should prevent such firms from operating a platform and competing with third parties selling on the platform, and also evaluating much more closely, or in some cases effectively prohibiting the acquisition of relatively small firms based on a concern that such acquisitions may eliminate future competitive threats to the acquiring firm. Such an antitrust program would, according to proponents, recognize and remediate the alleged power of large corporations to shape legislation, regulation, and political outcomes, and other non-economic and economic concerns. Now, such concerns are not limited to advocates in the United States. Every major competition agency in the world is grappling with the application of competition and consumer protection laws, particularly privacy laws or privacy considerations, to the increased use and application of digital and personal information in our commercial and personal interactions. The pressing concern, one that revisits the concerns of 20 to 25 years ago, think of the challenges to the rise and perceived dominance of Microsoft, is whether existing competition law is capable of successfully remedying anti-competitive conduct in technology markets. Those fast-changing markets where, if you move slow, you're not just left behind, you're simply dead as a competitive or a going concern. Now, this concern has come on remarkably fast. And I say this without critical. Senior enforcement officials of the just previous administration have concluded that their own enforcement and regulatory agencies and policies were sufficiently inattentive to the potential for anti-competitive harm from serial acquisitions of small firms by large firms and vertical integration through merger and expansion. Accordingly, many, including them, propose rapid and significant change in legal doctrine and enforcement policies as necessary to forestall or reverse a return to a Gilded Age. Now, in light of these concerns and concerns of advocates with respect to civil rights and social justice, political accountability, and private power, other jurisdictions, as well as us, have initiated reviews of their competition and consumer protection enforcement efforts. In the UK, the Chancellor of the Exchequer and the Secretary of State for Business, Energy, and Industry asked Harvard economist and former head of the Council of Economic Advisors, Jason Furman, to lead a review and to make recommendations on changes to competition and pro-competition policy in response to the development of the digital economy. EU Commissioner Vestager asked a team of experts to explore how competition policy should evolve to continue to promote pro-consumer innovation in the digital age. And as another example, the German Federal Ministry for Economic Affairs tasked the Competition Law Commission with drawing up recommendations for the further development of competition regime. So they concluded, in general, right? Well, they had different conclusions. These groups had mixed findings as to the strength of the current competition regimes. Furman's panel concluded that competition policy will need to be updated to address the novel challenges posed by the digital economy, and that while some of these updates can happen within current powers, legal changes are important to ensure that this job can be done effectively. Now, notwithstanding these relatively supportive words for the current competition regime, the panel also concluded that the biggest gains will come from going beyond these tools to focus on policies that actively promote competition, foster entry by new competitors, and benefit consumers. They recommend a digital code of conduct for the most significant digital platforms, measures that promote data mobility and systems with open standards and expanding data openness. Now, the goal of their recommendations, which of course I believe is the correct one, is to create a regime that allows competition and innovation to thrive. However, whether we get there by, as they recommend, working with businesses and other stakeholders to set up predictable rules in advance is, I think, questionable. The FTC's history in the 1920s with the trade conferences suggests some of the difficulties with joint agency, business, and stakeholder codes of conduct. Basically, they may lead to rules, and did lead to rules, that excluded new or particular competitors from competing, and led to managed competition, which is often just an excuse for raising prices. Now, the EU experts concluded there was no need to rethink the fundamental goals of competition law in light of the digital revolution, and found that vigorous competition policy is still a powerful tool to serve the interests of consumers and the economy as a whole, and cautioned against a new debate on the goals of EU competition law. In fact, a debate on whether consumer welfare is the appropriate standard for antitrust. Rather, they said what was needed was new thinking on plausible theories of harm backed up by an increasing theoretical understanding of the specificities of digitization and empirical evidence. Now, I'm not sure if they believe that this theoretical understanding and empirical evidence exists now, or just believe that, given this understanding and evidence, it's necessary to come up with some plausible theories of harm that recognize new forms of competition and new markets. Now, the German Competition Law Commission concluded that the EU and member states must develop an enhanced set of competition rules which take account of the pace of change in the digital economy and an enhanced framework for enforcing the law more quickly than has been the case. They also found a need to adapt the legal framework for European competition law without undermining the principles of competition law. Now, I don't agree with all the recommendations and conclusions in these reports, and there are many other reports, but they are thoughtful papers, and they influence the projects we in the Office of Policy Planning are working on as a follow-up to our competition and consumer protection hearings, which is basically a part of our review of antitrust doctrine. So we're doing, among other things, we're working on guidelines and guidance documents with the aim of articulating an analytical framework for the evaluation of unilateral conduct by allegedly dominant technology platforms, vertical integration through acquisition and merger, and certain horizontal merger transactions, including those that might eliminate future, nascent, or potential competition, and acquisitions where the concern is diminished competition for non-price attributes. Now, this effort will help us identify areas where the case law can be clarified or improved to allow for more certain and successful challenge to anti-competitive conduct. The Commission can achieve that clarification through its own case selection and amicus participation, or through a request or support for legislative action. It may also strengthen the basis and direction of ongoing or future investigations of dominant firm conduct or anti-competitive mergers through the development of case law and agency practice. Now, these guidance documents are intended to be enforcement documents. They're intended to state the agency's enforcement position with respect to certain unilateral conduct or merger transactions. In this respect, they have a similar purpose as the joint FTC and Department of Justice horizontal merger guidelines, intellectual property guidelines, and the competitor collaboration guidelines. Each of these documents that I just mentioned state the federal antitrust agency's enforcement intentions, lay out an analytical framework without fixing the application of the framework, and allow for changes through updates and revisions consistent with developments in agency practice and case law. Now, earlier this month, in conjunction with the Department of Justice, we released for public comment the first of these outputs, draft guidelines on the analysis of vertical mergers. The previous guidance was about 35 years old and probably 25 to 30 years out of date. And while antitrust lawyers practice in this space recognize that, courts and others less familiar with what we do day to day did not. So I want to compare our efforts, because this is a bit of an international group, to some of the recommendations in the Furman and EU expert reports. And I'll use the 6 strategic recommendations of the Furman report to illustrate the scope of what we're doing and show some level of consistency across jurisdictions. The Furman report identifies as its first strategic recommendation that to sustain and promote effective competition in digital markets, governments should establish and resource a pro-competition digital markets unit tasked with securing competition, innovation, and beneficial outcomes for consumers and businesses. Now, in February of last year, the FTC established the Technology Task Force dedicated to monitoring and reviewing competition in U.S. technology markets and investigating any potential anti-competitive conduct in those markets and taking enforcement actions when warranted. This task force has been upgraded to a division and will be a permanent unit within the Bureau of Competition. And this unit, in my view, is very similar to what the Furman team has recommended. In addition, the Office of Policy Planning continues to look for opportunities to secure the objectives that Furman laid out to the UK authorities. Opportunities to secure these objectives through advocacy at both the federal and state level. Now, as part of his recommendation, the Furman report calls for the creation of a code of conduct to govern the behavior of firms designated as having strategic market status. Now, I'm unsure of what the Furman team anticipated there, and I'm also somewhat unsure of what they mean by firms or the identification of the firms who have strategic market status, but I can bet, at least right now, they mean firms like Google, and Facebook, and Amazon. Now, given the difference in firms and markets that could be characterized as digital platforms or digital markets, and the relatively frequent review of what firms have strategic market status, firm or market-specific codes seem difficult to develop and subject to repeated and perhaps abrupt change, and this does not seem positive. On the other hand, the more general code seems potentially rigid. Now, as I suggested, we've proceeded a little differently. A high priority for us is to release a platform guidance document that articulates a framework for analyzing, identifying, and remedying anti-competitive conduct in platform markets. It will not propose do's and don'ts, but may serve somewhat the purpose of Furman's idea of a proposed code of conduct by providing substantial guidance about how we will enforce the antitrust laws, but without rigid conduct requirements or industry by industry rules against large technology platform companies. The Furman report calls for, as its second strategic recommendation, a reset of merger assessment in digital markets. They recommended that the UK Competition Authority take more frequent and firmer action to challenge mergers that could be detrimental to consumer welfare through reduction in future levels of innovation and competition, supported by changes to legislation. Now, it seems awfully unproductive to recommend or hope for legislative change of this type, in part because it's not clear such change is necessary. But we are taking steps, as I noted earlier, we're taking steps to update and articulate our framework for analyzing horizontal and non-horizontal mergers. And through this process, we're going to pay close attention to factors relevant to digital markets, competition on non-price factors, the effect of mergers on innovation, and the acquisition of small but potentially significant competitors. Now, one thing, participants at our hearing session on nascent competition made the point that the large tech firms have made hundreds of acquisitions in the past decade, some of which they suggest must have been anti-competitive. Now, a policy question for the Commission, and something we in OPP are considering, is whether the Commission receives pre-consummation notice of acquisitions, mergers, and other transactions that have the potential to substantially lessen competition or tend to create a monopoly. This inquiry is important because the agency's statutory right to review and challenge acquisitions and mergers of a certain size prior to the consummation is the primary means by which the Commission prevents anti-competitive concentration of markets, the maintenance or growth of market or monopoly power, and the extinguishing of future competition and competitive threats. I want to leave some time for questions, so I'm going to skip to the end and just call out the sixth strategic recommendation of the Furman report, which is that the UK government should engage internationally on the recommendations it chooses to adopt, encouraging closer cross-border cooperation between competition authorities and developing a common approach to issues across the international digital markets. Now, this is an area where the FTC has been the leading force amongst all antitrust and competition agencies for at least 2 decades under the leadership of Randy Treitel, head of our Office of International Affairs, and other folks such as Maria Coppola, who's a graduate of both the law school and the School of International and Public Affairs. She's a key person in this effort. So what's my core message? What we are doing at the FTC, and I think the same of other competition agencies, is intended to show that vigorous, aggressive, but thoughtful antitrust enforcement grounded in microeconomic principles is both capable of meeting the competitive challenges of digital markets and avoiding the negative effects of an overly prescriptive antitrust or regulatory regime. Now, it's possible I'll be proved wrong, but I don't think so. The issues critics of the prior administrations raise strike me as addressable where appropriate by competition law. Now, perhaps competition agencies were slow to recognize the anti-competitive possibilities associated with digital markets and digital platforms. Now, that's not a definite conclusion, but I'd say perhaps. But if so, the best of the agencies have been stirred to action and are now devoting substantial resources to inquiries in these markets. I think we should see what comes of these efforts before we act to upend them with revisions to laws that may neither be necessary nor beneficial and arguably potentially quite harmful. So I'll stop there so we can discuss a little bit.
I want to focus now on the present moment. So I think it's clear that we're at another one of these inflection points where there's a lot of questions over whether antitrust law or competition policy concepts need to be updated to respond to current challenges or whether they are capacious enough to deal with some of the issues that we're seeing in the digital age. And then there's also a closely related but I think distinct fight over whether the current tech giants should be subject to antitrust enforcement. So on the first point, on this question of antitrust concepts and whether they are relevant or updated enough for the digital age, I want to come back to what you said about the consumer welfare standard. And this is, as I understand it, and I will say I am not an antitrust lawyer, so my concepts of these issues is also in development. As I understand it, this is one of the key sticking points in this debate, is this question of how broadly can you interpret what consumer welfare means, and how should we evaluate that in the context of tech companies where often the services are free in the sense that the user is not paying for them, but in other ways the user is making a trade, either of their privacy or of data collection, or of agreeing to be shown certain things by the platform that they're using, that raise a lot of concerns in terms of freedom of thought, freedom of expression, but also just in terms of a few companies having a lot of power over what people are actually exposed to in terms of information. And critics of the current antitrust regime would say that consumer welfare, which often gets sort of conflated with the idea of is the consumer paying more for this or not, and if they're not paying more for it, then we're okay. Is that standard something that can be applicable to these companies? Do you think it needs to be updated? Do you think people are misunderstanding what it actually encompasses?
So that's a lot of questions.
Yes, I know.
It's a lot of questions. And maybe I'd say a few things in rapid order and see where that settles. So first, it's absolutely a mistake to think of the consumer welfare standard as focused on price. I think a look at the cases that the agencies pursue, both in litigation and in what turn out to be settlements, often focus on non-price factors or include non-price factors in the identification of the concerns. And that is largely on things like innovation, right? In fact, I'd say almost the focus of most of what we do is really intended to prevent mergers or conduct that restricts the development of new forms of competition. Right? Now, in homogeneous industries or industries involving homogeneous products, you're probably focused on price because it's simple. But outside of that, it's always, how will this merger affect competition for future product, in some sense, future products, innovation, and the better delivery of services to firms. Now, in a more practical sense, I've been an antitrust lawyer for 22 years, most of that time in private practice. And when a client came to us with a merger or questions about, certain conduct, and whether it was okay or likely to be challenged under the antitrust laws, we said, okay, tell us why you're doing this merger, tell us why you're engaged in this conduct, what are the benefits for consumers? And it wasn't always lower prices, right? Tell us a story. How does it affect price? How does it affect your delivery of services, for example, to consumers? How does this affect innovation, right? We'd have to have a story, right? So I think the focus on it's a mistake to suggest there's a focus on price. Now I think, and in fact, I'd say, and I said this in a classroom, I think the development of antitrust law over the last 40 years has been away from a focus on price and a redevelopment of the rule of reason, which looked at other things besides price and away from sort of per se treatment of conduct that was just categorized as opposed to reviewed for its effects. Now in zero price markets, arguably zero price markets, the platform companies are not the first to be in this space. At least when I was growing up, there was still free radio and free TV, and what they wanted was your attention to listen to a bunch of ads. Now, they didn't collect data the same way that companies collect data now, but there was surveys of what people were watching or listening to, and that was all driven by an attempt to sell advertising time to the listener. Now it's arguably more targeted, more sophisticated now, but it's somewhat the same business model. And the agencies have dealt with mergers or conduct in what I call zero price markets for a long time. Now, I think with the platform companies, there is a concern that either intentionally or unintentionally people are providing all sorts of data to those companies, and it's a little creepy. And thus, we're asked, should we take that kind of privacy consideration into effect when we do antitrust analysis? And I'd say, in some ways, the short answer is yes. If firms compete on privacy, if privacy is the dimension of competition, then we should take it into account. Now, the difficulty is, of course, determining whether firms compete on that dimension of competition, or understanding how people view privacy policies of firms as relevant to them. Most people like lower prices, right, as opposed to higher prices. But some people don't value their privacy. People don't have sort of monotonal, or homogeneous privacy functions. And of course, there are many other things that companies do and arguably compete on, or at least try to brand themselves on, that we don't consider. So, why? Look, I like my privacy, but I also like companies that don't pollute. And so, should I take into account a company's environmental policies in thinking about a merger? Well, maybe, but how do we do that? And it seems a lot harder than looking at things like how will this affect price, how will this affect delivery of services, how will this affect innovation. So it's a long way of saying there's nothing new about zero price markets. Antitrust law in those markets has usually focused on one side of the market, which is the advertising side of the market. It's not necessary for it to be that, but questions about privacy and sort of the general what some people might perceive as sort of the general creepiness of what these companies know about you and how they target you with ads. It's hard to get around. It's a little bit harder to think about, but I think certainly when firms compete on privacy factors or factors that are important to the consumer or their users, that's competition. And if a merger is going to eliminate that, well, we ought to figure out how to think about that.
Okay, thanks. I want to stick with the advertising model for a second, because I take your point that zero price markets have existed for a while, but I think that there are pretty significant differences between the kind of advertising that TV or radio stations have been able to do versus what some of these digital platforms are able to do. This came up a lot at the symposium that we held in November. A lot of people's concerns, especially around the aspect of online discourse, but I think I'm going to make the case for it as a competition concern in a minute too, is the advertising model. So these platforms make their money by selling ads to companies that they show to their users. But what they also do is they collect data on their users, on what you're clicking on your behavior, on what you like and what you don't like, and then they use that data to make more predictions about what you're going to click on or what they can show you. And that's, the advantage that they sell to companies is that they have these detailed profiles on their users so they can serve them ads that they're more likely to actually look at or engage with. And what that does is it sets up an incentive for these companies to keep the users online on their platform for as long as possible, and it serves them controversial content, clickbait, the type of thing that's going to keep you on the platform so that it can collect more data and so on. So to begin with, I would say, to me, that seems pretty distinct from the kind of advertising that analog broadcast type things can do. But I would also say, there's a competition concern that I've seen raised as well, which is that some of these companies now have so much data at their disposal that it makes it very difficult for new competing platforms or new competing ad services to get into it because they're just not going to be able to surmount that competitive advantage. So I'm wondering, how would an antitrust official think about something like that?
So, again, a lot of questions, and I want to take a little bit of a contrarian view on this. So, I don't watch over-the-air TV because I don't want untargeted ads, right? I don't want to sit there through ads for people who are not me. So I'm a little I'm not sure that people don't actually like targeted ads versus untargeted ads, and in some ways you give up some information in return for more targeted ads. But I agree, for some people it's creepy. We think of data as an asset, right? I mean, in competition law. So we have brought merger challenges to combinations of firms with sort of unique sets of data. Now that's usually commercialized data, and we are thinking about how would we think about a merger that involved two firms with what I'd call broad-based personal data, and how would we evaluate the efficiencies associated with that, but how would we evaluate the potential sort of foreclosure of that asset to some other entrant? And I'd say a couple things. It is worth thinking about, and we are. I think I hear a lot how the large tech platforms have a lot of personalized data, and I don't want to underestimate what they collect, but we also at the FTC we also operate on sort of the consumer protection side of the markets, and we see what what information brokers collect. A lot of people collect a lot of information, and they package it and sell it to lots of companies. Now, whether it's substitutable for data that some of these large platform companies collect is, I think, a factual question. But I think maybe we recognize that data can be an asset that can be used competitively, or it can be used beneficially competitively, or can be, if it's not shared with other firms, can prevent their entry or expansion in a market. But I think it's reasonable to question whether the companies have data that is so unique. It's a question for any of those types of analyses, is whether the data is so unique that it gives them a competitive advantage.
We are almost out of time, but I'm going to squeeze in one more question. So you mentioned at the beginning of your remarks speculative mergers are sort of trying to evaluate the potential future impact on competition of certain acquisitions. And I'm wondering if again, the digital age where tech companies change that analysis at all? Because I think one concern that I've seen raised is that companies are buying up companies that may be quite small right now and not profitable at all, but they're developing a technology or filling a market niche where if they were allowed to grow for longer, they might become a competitor. Facebook and Instagram is often something that's raised here, but they're acquired too quickly, and they're acquired by a dominant firm, and then that firm's dominance expands over the years as that technology is used in the firm's existing services. So is that something that current antitrust analyses already take into account?
So, yeah, I think the big issue with some of these transactions is, in a sense, we're always trying to predict the future, right? How will these firms develop, either alone or in combination? So antitrust law, first, the case law has developed a doctrine of potential competition, but I think the agencies have developed more sophisticated ways of thinking about both competitors and markets. They have concepts of markets for future goods, they have markets for innovation, and they have markets for technology. Here, I think the real difficulty is in part knowing, what the path is of that, as an example, that smaller firm absent the acquisition. Will it develop into a competitive threat? Will it develop into a unique competitive threat? Or will it not develop at all into a competitive threat because they don't have the skill, the capability to take it to that level? And the acquisition may allow, that technology, that product to develop in an integrated fashion. So it is certainly possible, and this is not speaking about Facebook, Instagram, or any particular merger, it's certainly possible to get those decisions wrong, right? We're, in a sense, doing our best to predict what's the path of the companies together and alone over the future. And the less information you have, in a sense, the harder it is to do that. So it's certainly possible we get it wrong. But it's certainly possible we get it wrong in either direction. We block a deal that we shouldn't have blocked, or we don't block a deal that we should have blocked. And that's a tricky question. And I think, without getting too far, and I think people who pay attention to these arguments, there's a real question of would these companies develop if they didn't have a strategy for being acquired, right? I mean, somebody sits down in the garage and says, I got a great idea, and in 18 months, I hope to God Facebook buys me, right? And if Facebook or Google or whomever is not out there, I'm not going to sit down in the garage and do that, right? Because it's a lot harder to get to market. So, we have to think of those effects too. And I think it's hard to predict the future.
Thank you. Well, that's all the time that we have. This was great. Thank you very much. Please join me in thanking Bilal.